What is attorney-client privilege?
It is the right of a client to prevent a lawyer from revealing a confidential communication essential to the attorney-client relationship. So one side has to be a lawyer, and that lawyer must actually be representing the client, and the communication must be confidential, and it must be about the subject of the representation. So if you see me in a hallway and say, let me tell you about the date I had last night, just because I'm a lawyer, that is not attorney-client privilege. But if you see me in the hallway and say, the case you're representing me on, that automobile accident I had, I forgot to tell you something, it's pretty important, I don't want anybody else to know about it, and you tell me, that is subject to the attorney-client privilege.
Does attorney-client privilege apply if the communication is about committing a fraud or a crime?
One of the exceptions to the attorney-client privilege, it's a slight misnomer. It's called the crime-fraud exception. It covers more than crime or fraud. So if the client is in the process of committing a crime, we're not talking about robbing a bank, but some crime that takes a long time to commit, or committing a fraud, or committing a tort, a civil wrong that harms someone, or violating administrative regulations, and they are talking about it or communicating about it, those communications are not subject to the privilege, meaning the client cannot stop the lawyer from revealing it, nor could the client prevent a third party, like the government, from acquiring evidence of it and using it.
Hypothetically, if you assume that, as Donald Trump said, he had no knowledge of the Stormy Daniels payment, then how could Donald Trump assert attorney-client privilege if he had no knowledge of that payment?
He couldn't. Here's what Michael Cohen is alleged to have done. This is right out of his own mouth. I represent Donald Trump, and we're going to pay you $130,000 not to talk about him. P.S. Donald Trump doesn't know anything about this. That's an act of fraud. Either he represents the client and is acting on the client's behalf and the client knows about it, or he's doing it on behalf of himself or somebody else and he's lying about it. One way or another, he committed a fraud. This is what the government alleges. And if he committed a fraud, a civil fraud by duping this woman, did he commit a criminal fraud as well? What would the criminal fraud be? The criminal fraud would be bank fraud, because he says he borrowed the $130,000. Did he tell the bank he was going to pay an adult film star not to talk about the president? Well, if he did, they would never loan him the money. Did he tell the bank he was going to put an addition on his house? If he did, then he lied to the bank, which is bank fraud. And if he wired the money obtained by bank fraud over interstate lines, that's wire fraud. And if he sent a letter confirming it, that's mail fraud. Each of these frauds carries 5 years in jail. That's what the government is pursuing him for.
If you assume that some of Donald Trump's communications with Michael Cohen were about fixing problems and not legal services, so those fixing communications would not fall under attorney-client privilege.
Correct, because then Michael Cohen was not acting as a lawyer. This is also what the government alleges. The government alleges that Michael Cohen has one client, Donald Trump, but much of what he does for President Trump and did for the pre-presidential Donald Trump was not legal work. It was fixing problems, and it was being sort of a dirty trickster, if you will. And those things, the communications between Trump and Cohen about those events, are not privileged because they are not about legal representation, and therefore the government can seize them in this raid and use them against either Cohen or Trump.